Hello friends, very warm welcome to my Business Laws channel. Last time friends, I took up chapter number 5 and in the very first lecture, I introduced the term consent, free consent, and then I talked about features of coercion. Now today will be the second lecture to chapter number 5, free consent. Points of discussion I have given here, they are before you. So friends, I'm going to begin the heading undue influence. Undue influence, as the name implies, the term implies undue influence, excessive influence by one over the other. Undue influence is another factor which affects the free consent and renders a contract voidable at the option of the party whose consent was obtained by undue influence. So this was a simple definition of the term undue influence. Undue influence has been defined under section. It has been defined under section 16, subsection 1. A contract is said to be induced by undue influence where relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and he uses that position to obtain an unfair advantage over the other. So friends, there are two very, very important points from this definition. So relationship subsisting between the parties are such that one of the parties can dominate the will of another. And not only that, he also uses that position to obtain an unfair advantage over the other. And now the question arises, when is the person said to be in a position to dominate the will of the other? Okay, so friends, now these cases have been provided under section 16, subsection 2. I'm going to take up these points. The very first point is where he holds a real or apparent authority over the other. For example, a relationship of master and servant, police officer and accused person. So the examples which I have taken here, the police officer has authority over the accused person. Similarly, master has authority over the servant. So when we talk about apparent is implied authority. This authority may be actual or it may be implied. Then where he stands in a fiduciary relationship to the other. Fiduciary relationship term means relationship of mutual trust and confidence. As we have any problem, then we never visit any doctor. We visit that doctor in whose we have reposed confidence. So the relationship between the patient and the doctor is of fiduciary relationship. Now coming to C point, friends, which is where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress. So maybe the person is not well. His mental capacity has been affected. He is having certain problem. Maybe there is an aging factor, or he has got certain mental problem. This, it may be affected for a temporary period or for a permanent period. So then also, friends, when person is not well during his old age, he is dependent upon others, then also his will may be dominated by others upon whom he is dependent. So friends, having discussed all these, I am going to take up elements of undue influence. The very first element is before you, which is dominance of will. So when we talk about undue influence, we do talk about two parties. One is a stronger party, other is a weaker party. So stronger party can dominate the weaker party. So advocate, the example is before you. A is an advocate and B is his client. That the relationship between A and B is such that A can dominate the will of B by charging unreasonable high fees. If he charges reasonable fees, then there is no undue influence. But if he charges unreasonable high fees for his professional services, this will be taken as the case of undue influence. The second element of undue influence is obtaining an unfair advantage. In case of undue influence, a stronger party may use his superior position and obtain an unfair advantage over the other. But we cannot generalize that, in every case, stronger party will definitely use his superior position and will obtain an unfair advantage over the other. So here is the example before you, where A, an advocate, asks his client B, who is a dealer in electronics, to deliver his television set to his house for his personal use. On delivery of the television set, A pays rupees 30,000, which B finds a case of undervaluation. Here A employs undue influence and the contract is voidable at the option of B. Now, third point is relationship of real or apparent authority. Now, real authority, actual authority, apparent is implied authority. Now, in my lecture class earlier, I have talked about relationships between master and servant, police officer and accused person, and income tax officer and assessee person. So, otherwise also, we do find that in various organizations, we find that superior post, inferior post. Then, the superior person who is at the superior rank can dominate the will of the person who is at the inferior post or inferior rank. So friends, these are the cases where there is relationship of real or apparent authority. Now, fiduciary relationship between the parties. Fiduciary relationship, you all must have understood. It is a relationship of mutual trust and confidence. Relationship between doctor and patient, spiritual guru and devotee, parent and child. So all these are trustee and beneficiary, fiance and fiancée, husband and wife. All these are the relationships of, fiduciary relationship. Then in all these cases, undue influence must be proved. Relationship of creditor and debtor, landlord and tenant, husband and wife. Mental distress is another element of undue influence. Sometimes a person whose mental capacity or strength is affected by reason of age, he is, running into the old age, and he is dependent upon others. Then also, the person upon whom he is dependent may dominate his will. Example is an old lady aged 80 met with an accident and fractured her right leg in an accident. She was being looked after by her relative. She transferred the whole of the property by way of gift to her relative. It was held in the court of law. The relative must have obtained the consent by undue influence. Therefore, the transfer deed was set aside on the ground of undue influence. Now, friends, I'll take up the heading Presumption of Undue Influence. According to judicial decisions held in the various courts cases, there is presumption of undue influence in the following cases. The very first is fiduciary relationship. Wherever there is a relationship of mutual trust and confidence, then we presume that, the parties' consent must have been obtained by undue influence. So relationships are doctor and patient, then guru and chela, and then a police officer and accused person. Unconscionable transactions. Unconscionable means to be unreasonable. Section 16, subsection 3 provides where a person who is in a position to dominate the will of another enters into a contract with him and the consideration in transaction appears unreasonable on the face of it or on the basis of evidence deduced from the transaction is known as unconscionable or unreasonable. In such a case, the burden of proving that such contract was not induced by undue influence shall be upon the person who is in a position to dominate the will of the other. So here, friends, the weaker party has to prove that her consent was not free one, it was caused by undue influence. All these presumption cases, the burden of proof lies with the weaker party. And now, example I would like to take, but every time, friends, charging high rate of interest does not amount to undue influence. Does charging high rate of interest amount to undue influence? The answer is not always. It depends. If there is shortage of money in the money market, there is, we may call, stringency in the money market, then in that case, charging high rate of interest will not amount to undue influence. For instance, A applies to a banker for a loan at a time when there is stringency in the money market. The banker declines to make the loan except at unusually high rate of interest. A accepts the loan on these terms because he was needing money. Because of stringency in the money market, his transaction in the ordinary course of business and the contract is not induced by undue influence. So if there is shortage of money in the money market, then charging high rate of interest will not amount to undue influence. Then the next point is contract made with the Padhanashin woman. Now the question arises, or you may ask, friends, what is the meaning of the term Padhanashin woman? A Padhanashin woman is one who observes complete seclusion due to traditions or customs of a particular community to which she belongs. So the burden of proving that no undue influence was exercised and consent to an agreement was free lies with the party who enters into a contract with the Padhanashin woman. So friends, all these presumption cases, the burden of proof lies with the weaker party. But if the party's consent was free one, then the stronger party has to prove that the Padhanashin woman's consent was free one, it was not caused by undue influence. So in that case, the party has to prove. He or she has to prove that full disclosure was made about the terms of the contract. She had independent and fair advice in the matter. She had understood her obligation under the contract. So friends, all these disclosures are to be made by the stronger party. Because otherwise, in all these three cases which I have discussed just now, it is always presumed that consent must have been caused by undue influence. And if it has not been caused, then in that case, the stronger party has to prove. The consent was free one, it was not affected by undue influence. And now the question arises, what is the impact of undue influence? Under three heads, I would like to discuss. The first is contract becomes voidable. Second is principle of equitable restitution applies. And the third is valid contract. All these 3 points are common in all these cases, whether it is a case of no coercion or undue influence, fraud, misrepresentation. So contract becomes voidable because the consent is not free. It becomes voidable at the option of, it becomes enforceable at the option of one or more of the parties, but not at the option of other or others. Principle of restitution. Restitution, you all know, friends. It is to return the benefit to the person from whom the benefits have been derived. Then valid contract, because agreed party has two options to exercise. One is affirmation, second is cancellation. If the party affirms a contract, then the contract remains valid. So friends, now having discussed undue influence, its definition and elements of undue influence, now I would like to discuss about, how is coercion different from undue influence? Now, first is the meaning. You all know, friends, what is coercion? Coercion has been defined as per section 15. So you will have to write the definition here in the first point. And undue influence is what? It is domination of will by one person over the other to obtain an unfair advantage over the other. And then, friends, second is type. Even type of force which is used is different. Coercion is mainly of physical character or violent force or physical force which is used. But when we talk about undue influence, it is a moral pressure, it is a mental pressure, which is exercised in order to dominate the other person. Third is a relationship. In case of coercion, no relationship is required. Parties need not be related, but relationship is must in case of undue influence. I have talked about various relationships during the course of my lecture class. Relationship between doctor and patient, relationship between guru and chela, relationship between mother and daughter, relationship between father and son. So there is some relationship. Then fourth is parties to the contract. The person exercising the coercion may not be a party to the contract. Coercion may be exercised by a person who may be a party or a stranger. And similarly, coercion can be exercised against a person who may be a party or stranger. But undue influence must be exercised by a person. The persons must be parties to the contract, dominating party and dominated party. And then presumption. Law never presumes it. It has to be proved by the aggrieved parties. But I have talked about presumption cases in the case of undue influence. Presumption cases were a contract made with a Padanishin woman or fiduciary relationship, or whenever there is unreasonable transaction, unconscionable or unreasonable transaction. So the burden of proof lies with whom? It depends. Are we talking about presumption cases or we are talking about no presumption cases? In presumption cases, the burden of proof lies with the weaker party. In case of undue influence, if there is no presumption case, then the burden of proof will lie with the stronger party. The restoration of benefits. The party who wants to set aside the contract on the basis of coercion, has to restore the benefits to the other person from whom the benefits have been enjoyed. So in other words, we can say it is a section 64 which applies. But here, a party has to restore the benefits as per the directions which are given by the court as per section 19A. Seventh point is coercion may even be exercised at a place where IPC is not applicable. I took the example in lecture 1 where regarding the high seas. At high seas, IPC is not applicable. But undue influence must be exercised in India. And now the last is criminal liability. Parties are committing the act exposed to criminal liability. Coercion is a crime. If parties commit crime, then in that case, the parties are exposed to criminal liability. They may be punished under the IPC, Indian Penal Code. And dominating party, they are not exposed to criminal liability in case of undue influence. Friends, now I would like to give you important questions from the second lecture. I have talked about undue influence and then elements of undue influence. After that, I took the effects of undue influence and then the difference between undue influence and coercion. This difference, friends, coercion versus undue influence. Difference between coercion and undue influence is very, very important from examination point of view. Very often this question is asked in the examination. So when you answer, do write the answer in the T form. It's all from my side, friends. I hope you will like the content. Do like my videos, do subscribe to my channel, do press on the bell icon to get notifications of my subsequent videos. Okay, friends, keep smiling always and stay blessed always. Okay, friends, we'll meet soon. Goodbye.